Hello, everyone. We are starting a great event, presentation of the book made by Pierre Orna, who devoted basically the whole his professional life, or the most of it, to serving the international community. And the outcome of this work was not only better institutions and better rules and principles for the world, which Pierre was working on with his great colleagues at UNCTAD, United Nations Trade and Development Organization, but also comprehensive work, which was the first research, academic research on fighting cross-border cartels. And this research we're going to discuss today with amazing, actually, panel led and guided by probably the most experienced and most demanded moderator of all competition world, Bill Kovacic. And I want to introduce the whole participants of today's show. I hope you will enjoy it, because we're not going to discuss the book itself. We're going to discuss the problem of fighting cross-border cartels, which is a very important topic for the post-COVID-19 world. So we have the author of the book with us, Dr. Pierre Orna, who is going to elaborate on his book and have a chance to present it to the world. It's first virtual launch of the book, and book is already on the shelves. So I encourage you to go to your bookstore, which is hopefully open. Don't buy it on Amazon. We don't promote these giants, do it offline, do it traditional way, paper, it smells, it's very nice. So we have our moderator, Bill Kovacic, professor from George Washington University, and that's one of the greatest minds of the competition world in this continents, on both continents, United States of America and here Eurasia, where I'm speaking now from, but also Africa knows him very well, and so on. We have two introductory remarks coming from Teresa Moreira from UNCTAD, who actually Pierre's boss, and she inspired his work tremendously on working on this book, and Antonio Capabianca, who is representing a competing firm, also working on international agenda for competition law and policy, but mostly representing developed world at the OECD, Organization for Economic Cooperation and Development. So we have also a great panel combined of competition authorities, not exactly young and small ones, but we all young in our hearts. So we have European Union Authority, European Commission, represented by the deputy head of the anti-cartel division or anti-cartel unit, which is Marissa Tierno. We have Russian Authority, represented by the deputy head of anti-cartel division as well, Muhammad Hamukov. And we have Authority of the Republic of South Africa, who is represented by the deputy head, Hardin Ratchesouso. We also have three great practitioners. We have Dave Anderson from the London-based law firm, which is dealing with competition issues for quite a lot, called Brian Cave Laketon Fraser. I can confuse the last family name, sorry, of the partner of your law firm, but you will correct me later on. Then we have Claudio Lombardi from another Eurasian country, Kazakhstan, who represents the local university KIMEP, but also has a great experience in working in Central Asian region and co-chairs the Eurasian chapter of the ASCOLA Association for Antitrust Scholars. And we have Juan David Gutierrez, who is director of another ASCOLA chapter. And this ASCOLA chapter represents Latin American countries, and Latin American countries and Caribbean is the focus of the Pierre research on fighting cross-border cartels. And myself is representing BRICS Center. We're hosting the event, basically supporting this great presentation, and we are happy to disseminate this work. We also do some empirical study on the basis of the principles and ideas which Pierre elaborated in his book. And this empirical study on fighting cross-border cartels based on questionnaires which were submitted by 31 authorities up to date, but we're expecting more, is going to be present. Preliminary results of this study going to be presented at the UNCTAD conference in October. Hopefully in person we can meet together there and discuss and continue our discussions about Pierre's book. And also we see a little bit of empirical study based on the findings of this book. And now I turn the floor to the moderator of our session today, Bill Kovacic. Bill, please, floor is yours. You can control manipulation of the discussion sphere, but also please encourage efficiency, of the speech of all the participants. So be balanced as you can do it. Please.
Alexei, thank you very much. And all of us are grateful to BRICS and your colleagues, yourself, Anna, the entire team that's made this possible. The only people who think it is easy to put these programs together have never done them. And what we see is the great skill that you have brought together to do this, as well as the tremendous intellectual vitality that the research program at BRICS, spurred in many ways by your own contributions, has brought to the field. And I think we're going to be talking a lot today about how important that contribution is. So thank you for providing the intellectual and electronic glue that holds us all together in this field. We're going to start, as Alexei said, by presentations from representatives of two of the organizations that have done indispensable work in creating a sense of global norms and the understanding that goes into the preparation of those norms. In a world in which we have over 130 jurisdictions with competition laws, there's an urgent need for some degree of interoperability, some common understanding of what's being done, some mechanism for bringing together the experiences of different institutions for the purpose of identifying what works and what could work better. Again, without a set of unifying organizations to provide that perspective, our field would be very poor, and we would be limited to trying improvements on a nation-by-nation basis. And I think all who are present in our program as presenters, and certainly our audience, realize that individual initiative by itself will not solve these problems, that the problems will be proceeding with the speed of a Formula One racer, and we will individually be riding bicycles to catch up. And that's not a fair fight. So the work that both UNCTAD and OECD are doing in this area are indispensable. And I'd like to turn first to Teresa to give us her perspective. Again, thanks to all that you've been doing, and thanks to charting a way ahead for us. Thank you, Teresa.
Well, thank you very much, and good afternoon, good morning, good evening. Greetings from Geneva. Thank you very much to Alexei Ivanov, to the BRICS Competition Law and Policy Center and your team for organizing this event. Thank you for the kind words of Bill Kovacic, who is such an important partner and a big supporter of our work in developing countries. I would like just to touch upon a couple of points to get the discussion going. First of all, just to say that even though through the COVID-19 crisis, we were facing a transnational, international, global pandemic, we saw mostly national reactions and responses. But fortunately, in what concerns competition law and policy, competition authorities and those involved in policy making in this field were very eager and very keen to exchange information and to exchange experiences, especially trying to support the less experienced, the younger, the smaller competition authorities, mostly of developing countries. UNCTAD, of course, tried to gather such information and encouraged and animated, participated and organized some discussions, because we thought that was very important to support colleagues across the world. And I have to say that we are still doing that throughout the summer due to the different time zones and summer breaks, especially in the Southern Hemisphere. Having said this, of course, since 2015 at least, so actually previous to my arrival in UNCTAD, UNCTAD has been focusing on international cooperation in competition law enforcement, obviously on the basis of the UN set of competition principles and rules, which have a section F, that most of you are very familiar with, devoted to international cooperation. And I'm very happy to say that thanks to the combined efforts and commitment of a lot of competition authorities, experts, and very relevant stakeholders, we were able last July here in Geneva in our intergovernmental group of experts meeting to agree on guiding policies and principles regarding the facilitation and encouragement of cross-border enforcement cooperation, mostly dedicated to assist developing countries and countries with economies in transition. So these guiding principles really benefited, first of all, from the initiative of the Russian Federation Federal Anti-Monopoly Service, which I like to especially greet and thank for providing all of us this opportunity, and to all of these colleagues and friends that intervened so actively during the discussions of our discussion group that led to the draft and consensus on the guiding policies and principles. My second point then refers to the guiding policies and principles. I would like just to bring the issue to share with you exactly the agenda of our forthcoming, oh my God. Okay, I hope you are being able to look at it as we speak. Let me just, okay, so we were expecting to have the, I hope you are seeing this, the UN review conference of the UN set of competition that takes place every 5 years, and that for the first time this year will actually also hear on our mandate on consumer protection. The UN conference has a very wide agenda. This agenda includes, of course, several important issues on competition law and policy. The most important regarding these matters are the guiding policies and procedures that we expect to be formally approved, and that should be read in conjunction with the UN set of competition as of October this year. But we also are holding two interesting roundtables, one on combating cross-border cartels facilitated by the Russian Federation Federal Anti-Monopoly Service, another one on competitive neutrality facilitated by the Austrian Competition Authority, both of which are very relevant to the current pandemic times, but also to the current topic of this webinar. We will also have the peer review of the West Africa Economic and Monetary Union, and a substantive session dedicated to competition and consumer protection strengthening in the digital economy. I would like finally just to say a few words on Pierre Horna's research, to say that, I have very little credit. It was very nice of Alexei to mention me. I do know that Pierre has been dedicating a lot of his time and a lot of his efforts to do this research. I would like to say that it took and make the most out of a sabbatical leave to complete his research, which he very successfully discussed here in the graduate studies of Geneva. So I'm happy to see that a team member of the Competition and Consumer Policies branch of UNCTAD is actually dedicating study and concrete efforts trying to improve our work assisting small and young competition authorities in a very important topic. And having said this, thank you very much for the invitation. That is all from my part.
Teresa, thank you for getting us off to a great start and highlighting again the vital contributions that the international networks make to providing guidance to individual nations, but assisting in developing norms and standards that improve performance across the entire range of institutions. As we'll say more, I think again, it is very encouraging to see how you and Antonio, whom we'll turn to soon, have provided a home for research that provides an opportunity to tie together what we've been doing instead of simply fighting and putting out the next fire, to stand back and ask, why do we have so many fires and how can we have fire prevention? And that research and analysis function, I think, is so crucial. It's part of what BRICS has been investing in, and you draw that out in a very informative way. Antonio at OECD, again, just a remarkable part of the intellectual infrastructure of our field. And the program, as it's evolved over time, has featured continuing improvements, especially, as Teresa has already indicated, improvements that feature efforts to ensure that institutions do work with their counterparts on a regional basis, on a global basis, to realize the gains that can come from collective effort rather than simply individual measures. Antonio, please carry on.
Thank you, Bill. Hello, everyone. Let me start from where you started and thank the BRICS Competition Law and Policy Center, Alexei and Anna, for hosting us, for hosting this webinar and this discussion. And thank you, Bill and Pierre, for the invitation, of course. I think the first words are words of congratulations for Pierre for the release of his book. I have to say that when he contacted me quite a few years ago, when he was starting his research, I was delighted to see that his interest coincided with mine. And I was actually very jealous that he could spend a year in sabbatical to go deep into these two topics, very close to my heart. And of course, as you said, very close to the mandate of the competition committee at the OECD, cross-border cartels and international cooperation. As many of you know, and Bill mentioned this, the OECD has been doing a lot of work in setting standards in both areas. We have two recommendations, a recommendation on hardcore cartels from last year. It's been sort of a refreshed and older recommendation. Same thing happened with international cooperation in 2014. We continue doing work in both areas. We've done roundtables on leniency, sanctions, very recently on criminalization, bid rigging, of course. And we are currently working extensively on international cooperation together with ICN, but building also on the work of Teresa's team and Pierre, of course, with the enforcement cooperation. So I will not talk so much about all of these things, but I thought to use my 5 minutes to give you maybe a few facts about cartel and cross-border cartels in particular, and maybe link them to the need for more or for better international cooperation. I hope that this will show how Pierre's research is critical and will continue to be important in the coming years for organizations like ours and for the policy debate that takes place in multilateral organizations. So the first fact, I think, is very well known, is that cartel enforcement remains the most important part of competition authorities' enforcement activity. Let me put a few figures to give you a sense of the dimension of these facts. We have data from 55 jurisdictions, which cover approximately 50% of the world population and 55% of the world GDP. And in 2018, in these 55 jurisdictions, there have been 465 cartel decisions, a number that has been growing every year steadily. And the part of the world or the region of the world which has been leading this growth is definitely Asia. They have the highest increase in terms of cartel enforcement of decisions in the cartel area between 2015 and 2019. Now, when it comes to international cartels, discovered and then sanctions, again, the number have been increasing since 2012 onwards. We have an average of 30 to 40 investigations every year around the world on cross-border cartels, international cartels. Approximately 1/3 of these decisions, of these investigations, are on bid rigging conspiracy. So bid rigging where a foreign firm is involved in the bid rigging conspiracy. Now, the vast majority of these cross-border cartels, about 80%, have been sanctioned in one single jurisdiction. These must be local and regional level cartels, not truly global cartels, because when we look at the global cartels, this percentage of cases investigated and sanctioned by one jurisdiction dropped to 32%, while 68% of these cartels are sanctioned by multiple jurisdictions. What does it tell us in terms of international cooperation? It tells us that a lot of jurisdictions, a lot of authorities are not yet active in enforcing their national law against global cartels. These are cartels who have an impact and effects on consumers around the world in many jurisdictions, but still only a handful of those jurisdictions actively pursues these illegal conduct. So there is a role for more and better international cooperation that can help more countries enforcing cartel laws domestically, and that means more deterrence globally. The second fact is that the success of cartel enforcement programs really goes hand in hand with the dissemination of leniency programs. Now they are, I would say, almost ubiquitous. I think all of OECD, I'm sure all of OECD member countries have a leniency program or an amnesty program. And the growth of the dissemination of these programs has been exponential. If you think that in 2000, there were only 10 jurisdictions who had a leniency program, 10 years later, those jurisdictions grew up to 60. And I think in 2017, we counted 89 jurisdictions. So clearly a success, one of the biggest success when it comes to policymaking and standard setting and sharing of experiences internationally. But we've seen these programs suffering a little bit in recent years. So the number of applications on average has been decreasing in the last 3 or 4 years. I think we had an average of 14 applications per country. Again, the pool of countries, 55 countries that we've been sort of surveying. So we had 14 on average applications, leniency application in 2017. They dropped to 7 on average per country in 2018. There may be many reasons for this, but certainly the fact that leniency programs do have a common objective, providing incentives to discover new cartels from those who are part of the cartel, they are different. They're really different between jurisdictions, and that may have these differences, regulatory differences, transform themselves in regulatory costs, and that may have an impact on incentives to apply for leniency in the first place. So more coordination, more cooperation on leniency program is something that is welcome, and some have even made proposal of one-stop shop systems, maybe at regional level, where an application to the one-stop shop works for all the countries being part of the system. Now, another area that I want to flag very quickly is fines. We know that corporate fines are still the most widely used form to sanction cartel conduct, and fines have been growing steadily again over the last 2 or 3 decades. Just to give you a sense, between 2011 and 2015, the total number of euro fines, or in value of fines, corporate fines, has doubled in the space of a few years. Of course, there are many reasons why this might be the case, but the trend is clearly there in terms of growing and increasing fines. Now, but there exist still differences there between jurisdictions, with corporate fines being on average 3 times higher in OECD countries as opposed to non-OECD countries. Again, there may be reasons, turnover that generated mostly probably in the OECD area, that's why fines may be higher, but I think there is still scope for smaller jurisdiction, newer jurisdiction to enforce their fining policy better. Again, cooperation can help with this to avoid double counting international cartels, so there is an important role for cooperation. Criminal enforcement is growing. Again, individual fines, whether civil or criminal or administrative, can play an important role in enhancing deterrence. We've seen more jurisdiction adopting criminal powers, although the criminal sanction imprisonment is still a rather rare outcome of cases in many jurisdictions, but we've seen numbers growing there as well. Now, when it comes to cooperation, the dissemination of criminal system creates challenges because it makes it difficult for agencies in the criminal system to dialogue and cooperate effectively with agencies in administrative systems. So that's a challenge that's been flagged and where we've been doing some work. Now, on cooperation more generally, and I close with that, Bill. We've seen that we're doing work recently with ICN on this, on enforcement cooperation across enforcement areas, so not only on cartels, but when it comes to cartel investigation and cross-border cartel investigation, respondents have really reported that better cooperation, better international coordination of enforcement activity, and more exchange of information is taking place. It is a mixed bag, though, because there are still a lot of legal challenges to exchange information, especially confidential information without waivers. And in the cartel area, that is a stumble block at times because you don't get waivers as easily as you do in merger cases. And this issue of the dialogue between criminal systems and administrative system is one area which has been flagged as an important challenge. On the plus side, we've seen much more coordination when it comes to down raids in parallel investigation or coordination of enforcement activities more generally. We've also seen more investigative assistance between authorities, joint interviews, dawn raids on behalf of a sister agency, especially at regional level. The ECN or the Nordic Alliance is a good examples of those. Now, I've not mentioned COVID, which I know is the third keyword in today's webinar. I know others will touch upon this. I will only say that we've seen in the past that cartelization has always been on the rise during economic crisis. The incentives to cartelize go to the roof. So I think cartel enforcement, cross-border cartel enforcement will remain and must remain very high on the agenda of enforcement. So the work of Pierre and these webinars are still quite important contribution to that debate. So with that, I thank you again for the invitation and for the opportunity to share just a few thoughts. And again, congratulations to Pierre for his wonderful book. Back to you, Bill. Thank you.
Thank you so much, Antonio. I think one consequence of being in the midst of this shattering crisis is that it forces you to ask questions about how systems function and how they operate. And you could model cartelization as a pathology that affects the competitive process, both on a local level, but on a global level. And what you've been describing is approaches that all of us can take to addressing the pathology. One major theme you mentioned is that if our jurisdictions, if our competition systems try to do it in isolation, there's a great likelihood that they will not learn ways and approaches of dealing with the problem and understanding how the relationships among the jurisdictions affect how the pathology develops. And you've focused the spotlight on that. You've also focused the spotlight on treatments. That is, what have we been doing to address this? The leniency innovations, the change in thinking about fines, the thinking about criminal sanctions, all part of the process. But posing the question you mentioned, which is, if we were healthcare professionals, are these treatments working? And even if they work for a while, do they continue to work as we see adaptation and adjustment by the business operators? And underscoring again the crucial role of having institutions that are collecting data and analyzing paths for improvement. And I think that's what you and Teresa are doing by way of providing a vital service in our collective efforts to deal with this pathology, which is a stubborn one. And for the history of our experience, has shown no sign of basically going away and giving up. It is a pathology that adapts, mutates, and comes back in another form. So our own dynamic adjustment is so important. We'll turn to Pierre to give some thoughts about the book. I think, like you, it can be a bit overwhelming to see all the attention that's given to big tech dominant firm behavior. You can attend 3 or 4 webinars a day. I think there may be 10 going on right now with big tech, abusive dominance. What do you do? It can draw all the attention away from this traditional topic of cartels. But what you've reminded us is, and what Pierre's book reminds us, is that that problem has not left us. And it is a basic problem that deals with the well-functioning of an economy. Cartels may not be what my students call cool stuff today, but they are enormously important to what we do in thinking about competition law. And Pierre's book draws us back into focusing on this pervasive problem that has such a cross-border dimension. And again, so impressively, it's not just the product of conceptual abstract thinking. He gathered a lot of data. He talked to lots of people in the process. He's put it all together in one place. And in doing that, he simply produced the best treatment of its kind in the world today. Pierre, can you give us a snapshot of what's there, please?
Thank you very much, Bill, and thank you very much for your kind presentation. I am very much flattered by what you just said now, but I would like to, first of all, thank everybody who is being with us today. And I would like, of course, to say good morning, the Americas, good morning, afternoon, or good afternoon, Europe and Africa, good evening, Asia. Thank you all for being with us today. It is my pleasure to deliver a very brief presentation on my book, Fighting Cross-Border Cartels, the Perspective of the Young and Small Competition Authorities, published by Hart in March 2020, just the time that the COVID-19 pandemic started to spread all over the world. First of all, as you can imagine, I am a UN staff member, and my disclaimer first: the views given today and in my book are strictly my own and do not represent the official position of the UNCTAD Secretariat and or its member states. Having said that, of course, I would like to thank the BRICS Competition Center in Moscow for having agreed to host the launching of my book, and to all speakers and the moderator, Bill, of course, for having agreed to provide a testimony of this subject matter. Ladies and gentlemen, in 2017, when I decided to embark on this academic adventure, the world was totally different to what it is now. Nobody predicted, except Bill Gates, of course, in 2015, that a devastating pandemic will change dramatically and so rapidly the way humankind lives and interact with each other. Now, we are in the most severe economic recession in almost every single jurisdiction around the world. And many predict that we will never get back to the normality that we had before the pandemic. But yet, as just Bill said, even in the most severe recession the world has ever seen, international price fixing cannot be excluded to happen in many jurisdictions. My book attempts to explain how most competition authorities, particularly in the developing world, can effectively fight against the most egregious form of price fixing that affects the lives of millions of consumers and micro, small, medium enterprises worldwide. Due to time brevity, I will not be able to provide you with a detailed account of the whole book, otherwise you will not buy it. However, let me highlight 3 points that are of relevance in this particular time of crisis. First, some remarks about the industry cartelization as per chapter 2 of the book. Second, I will briefly discuss about the solutions proposed for younger and smaller authorities detailed in chapter 8 and 9. And third, I will end up with final reflections about the relevance of the book in times of COVID-19 and beyond. On the industry cartelization, as we have witnessed, global cartel investigations dominated the headlines until recently, and it seemed clear that coordinated international enforcement would be the way for the future. However, it has been recently said that there is a decline on global cartel investigations worldwide after a big wave of international investigations, such as the one undertaken traditionally by advanced, mature, or bigger competition authorities worldwide, notably the case of auto parts and shipping. The book provides a different angle, though, by focusing on different types of cartels affecting precisely younger and smaller agencies worldwide. In fact, when I wrote the first manuscript in 2017 at Oxford, thanking, of course, what Teresa said earlier to the UN sabbatical leave program, I somehow predicted that global cartels might not be the best type of cross-border cartel to be tackled by younger and smaller competition authorities, but other forms of cross-border cartels. That brings me to the classification of cross-border cartels I detailed in chapter 2 of my book: import, export, regional, global or multinational, and finally, the fifth type of cartel, which is called, or I call it, transnational cartels. While this classification was made pre-COVID-19, it turned out to be very timely and relevant now, I believe, for the post-COVID period when detecting cartels because of the level of penetration that these cross-border cartels are affecting in developing countries or will be affecting in developing countries and economies in transition. I will come back to this point in the last part of my presentation. Let me now go to the second point, which is related to solutions and tools for younger, smaller agencies, chapters 8 and 9 of my book. My book suggests that the 2 of the 5 types of cross-border cartels can be effectively tackled by younger and smaller competition agencies, I'm referring to regional and transnational cross-border cartels. Let me detail very quickly on the solutions proposed for the problem of transnational cross-border cartels, where it's very much in line to what the OECD and UNCTAD efforts have been doing so far in the last years. Trust is the first part that we have to build up and build up even more. One of my interviews that I always remember from Australia said that trust is the lubricant that oils the international cooperation engine. And I would like to quote that because it is very important for us to strengthen the level of trust, but also the information. So there are three questions here: how, what, and where. How on the trust, what to share on information, and where the platform. On how, we're introducing in the book calculus-based trust activities between competition authorities. And when we discuss in our very extensive interview I conducted to you, Bill, the role of technical assistance and capacity building in creating trust between mature and younger competition authorities should not be underestimated. And in this part, this is the first point that I'm posing on this particular angle. What to share? In the book, we propose the idea of incorporating the international benchmark of the definition, as I call it, shareable information. Not to go into the international benchmark of perhaps dead attempts to try to define the definition of confidential information. And of course, that will lead us to the last point, which is which platform. I think it is important to understand that the International Competition Network has provided a specific framework for the promotion of sharing non-confidential information. What I claim in the book is that that particular framework can be strengthened by the introduction of Section F of the UN set on competition, now operationalized through the guiding principles and procedures under Section F, as Teresa mentioned earlier, on the work of UNCTAD in the level of the discussion group of international cooperation. Now, for the last part, which is regional cartels, I incorporated two different ingredients in the issue of trust. We know that neighboring countries will have different specific areas. In this particular area, the knowledge of trust might be different between mature and younger ages amongst younger agencies. And in this particular area, I introduced the concept of knowledge-based trust, which underlines the efforts of these competition authorities that are neighboring countries to know each other's needs and priority. We did an example some years ago in Latin America with the signature of the Lima Declaration at the OECD Latin American Forum of 2013, where Colombia, Chile, and Peru signed an agreement. But there's also another issue that I incorporate. We need to make a shift from cooperation to coordination when it comes to regional cartel investigations. And I propose here to use game theory applied to competition law analysis with the benefits of using coordination games. The idea would be to align strategies and information gathered from cartel enforcement cases happening within and among neighboring countries. Without explaining more on this, I would like to go to the last point of my presentation, which is the area of COVID-19 and crisis cartels. Ladies and gentlemen, the discussion in the last months about crisis cartels and COVID-19 have come back again on the table, particularly when many competition authorities worldwide are adopting some exceptions to the application of competition rules to certain anti-competitive agreements by horizontal competitors. The latter, at the same time, could potentially and inadvertently, and that's what Bill said earlier, facilitate the formation of hardcore cartels, including cross-border ones, the most difficult ones to detect, that adversely affect trade and consumers worldwide. It is true that COVID-19 has triggered a high volatility of prices, and that can lead to crisis cartels, such as the ones happened in 2008 at the financial crisis. Many sectors were actually including entering into collusive agreements, such as the French beef, auctions houses, German banks, carbonless paper. In Asia, to name one transnational cross-border cartel under the definition of my book, took place in the rubber industry between some producers in Thailand, Indonesia, and Malaysia. But it is important to understand also that COVID-19 has pressured everyone to go digital or virtual. And one could imagine an increasing market concentration, the absorption of failing firms and decline MSMEs. Those SMEs that do not adapt will disappear from the market. The digital market is the key problem here. The so-called digital giants, the GAFA, have sent unequivocal signs of concentration. According to a Financial Times article issued earlier this month, 19 acquisitions since the start of this crisis have led to a faster pace of acquisitions and innovations worldwide. Finally, a point that concerns me is the potential cross-border cartelization, potential, I remarked, and I stress, in the pharma global markets as a result of the wild race to find the vaccine against COVID-19. The progression of COVID-19 worldwide kickstarted a race to find a vaccine, as we all know. Many multinational corporations in the pharma industries, biotechs, non-profit research institutions, and led to hundreds of collaborations between academic research centers, private and public sectors across the globe. 2 days ago, 3 labs are winning the race ahead of others. I'm talking about the Oxford-AstraZeneca partnership with third-phase testing Russian volunteers, the US drug maker Pfizer and Germany's BioNTech, and finally, the CanSino Biologics in China, with currently testing in Sao Paulo, Brazil. It seems to me that these 3 collaborations and partnerships among pharmaceutical actors will definitely have a large share of the world market if the vaccine against COVID-19 is finally tested, and I would presume maybe until the end of the year or half of next year, particularly the one in Sao Paulo, where thousands of volunteers have agreed to test the Chinese vaccine. Several questions arise to this problem, and I will end up my presentation with 4 questions. First, with all these research capabilities and potential, how much will the market be impacted in the short and medium term? I think this is a very important area because we need to undertake some type of assessment in this particular area. Second, is there a danger of triggering global or at least transnational anti-competitive practices post-crisis? What about the proofs of investigations in South Korea with Sanofi? What would be the options available for developing countries' competition agencies to counteract this potential anti-competitive effect? Would the solutions and proposals of my book can provide an avenue, that will be the last question, for these younger and smaller competition authorities wishing to be protected from the harmful effects of cross-border cartels as a result of potential concentration in the pharma sector due to the race of vaccine against COVID-19? I end my presentation here with these open questions, hoping that my fellow panelists and commentators might wish to address some of them. Thank you very much for your kind attention.
Thank you, Pierre, for the wonderful synthèse of the key themes in your book. I'd simply add that part of what you do very well is to bring theory and practice together. A very attractive feature of the book is that it's not simply a collection of abstractions, that you distill from your research and from the theory very practical suggestions for how agencies, old and new, can improve their capacity to deal with these different phenomena and to work better with other institutions. And in that respect, it's an extremely valuable contribution to the literature and a highly useful guide for individual jurisdictions to think about what to do, as well as the larger international community. Second, I think it highlights again the contribution that can come from international and regional networks that have a research agenda. To have an opportunity to reflect and to distill lessons from a larger body of experience. Who knows if we will come up with good solutions and apply them over time. But a benefit from your work, again, the work that Antonio's done, the work that Alexei is helping guide and drive in BRICS, the work that Escola encourages, is that we will be much better aware of what the problem is. And by knowing what the problem is in advance, to begin thinking about solutions coming out of the crisis, going ahead, we'll have a checklist of what to look for and think about. I don't know if we'll have good answers, but it really helps to have some idea what you're dealing with, and that's what you've prepared us to do. Going to turn now to reflections and observations from representatives of 3 competition authorities. And thanks to Pierre, to Anna, to Alexei, we've got 3 of the best. 3 real success stories in our field. European Commission, DG Comp, I think without question, the leading competition authority in the world today, premier in its standing and in its influence. The Federal Anti-Monopoly Service, which for any number of reasons is a great success story among the newer cohort. And then the last, the Republic of South Africa, the great success story on the African continent and a real model for jurisdictions around the world. Marisa, if you could start us off, the reflections from the enforcers.
I am now unmuted. Thank you very much. To start with, I want to say that I am very honored as well to be part of this launch of Pierre's book, and that he has spoiled me by even mentioning me, quoting me in the book. So I had no other choice but really participating in this and reading the book. And I have found there, in the special focus on the needs of the younger competition agencies, some information that I didn't know and that I found very interesting. So even for practitioners, it is useful to get to have a look at the book and think out of the box. Now, I wanted to say that the European Commission obviously invests a lot in cooperation in individual cases and also in the international fora. We have here representatives of the OECD and of UNCTAD, but you know that the agencies, we also have our own group of agencies doing cooperation in the ICN, International Competition Network. And we come together every year in workshops and also in more general gatherings. I will speak about that at the end. The point I wanted to say is that, of course, the European Commission is an authority that only investigates international cartels, in the sense that we only investigate cartels that affect trade between member states. But even if you take it to, and in that framework, we have the European Competition Network that has already been mentioned, and which is the closest cooperation existing between competition authorities in the world. And I understand that it is also a reference for other areas. It is a success story. But now I'm going to focus more on the global side, because also around half of our cases in the last 5 years on average are global cartels, if you understand them being wider than the EEA. And then from a practical point of view, which is what I can offer as extra, I wanted to say that cooperation may be critical at the start of investigations, as we know. So to ensure certainly the surprise effect of down rates in some or all the jurisdictions that are concerned by an investigation, and to ensure that we don't have contradicting requests or conflicting timing in our investigations. But we also have more delicate issues, like, for instance, avoiding or mitigating the impact of the steps in the different investigations. Examples of these are, for instance, when we are confronted, which happens very often, with global investigations in which we have jurisdictions who can prosecute individuals criminally, and jurisdictions like mine that cannot prosecute individuals, and for which individuals are essential in order to have the input for the leniency applicants, which in our case are not individuals, but always companies. And then those other jurisdictions may be preventing individuals from discussing with their employees the case for a while they are being, subject to proffers or to questioning. Well, the fact that we go through this together, the fact that we are aware and we reach out makes that sometimes it is possible to reduce the time an individual is subject to this, and we are able to advance in our jurisdictions at another pace. It is the same thing. There are jurisdictions that all have the possibility to go against individuals, and then they have arranged sometimes to hear the same individuals in one go in joint visits, for instance. Other kinds of cooperation one thing that I always say to the parties who are cooperating with me, but also to the other jurisdictions, is please do not direct requests for parties to produce as documents the replies that they would have provided to the European Commission. Don't say, give me everything you gave to the European Commission, because you have your own powers to investigate the case. And if you do it by reference to my file, then there will be a replication of my file somewhere else, subject to different warranties, probably different parties, different timing for access, different rules. So I need to protect my file. I need to protect the warranties that my legislation provides to the parties. And cooperating with other jurisdictions makes them take this into account. Another thing is that cooperation is sometimes extremely useful to the parties, not only to the authorities. For instance, I have experienced in settlement cases that parties may actively, very actively request that we share our approach with another authority if they spot divergences of approach. And they would like that we discuss the scope of the cartel, the theory of harm, or the analysis we have, so that they can then settle with the different authorities and acknowledge therefore their liability, but then on compatible terms regarding the same cartel, because afterwards they will be faced with damages claims, and you wouldn't have, they don't want to have different decisions with different scopes. Then the final part of what I wanted to share is the informal setting for cooperation, which is extremely important, I find. DigiComp has sometimes exchanges of officials with other authorities for limited time. And I want to share, and I'm going to mention her. For some months in 2014, we had Liz Pruitt in DG Competition at the Cartels Directorate, who was at the time US DOJ prosecutor. And during that time, she presented the the American system to us over lunches and breaks, and we could ask her all the questions we had really in full confidence. And I did the same the other way around, explaining the EU system, but then really with the background for our choices in matters such as the leniency program or the EU settlements. The point is that the insight we gained was really invaluable to understand the mutual requests, the mutual expectations, and the constraints. And that allows us to cooperate better with our colleagues. So then, equipped with the precious knowledge of what was more strikingly different between the systems and what terms had really a different meaning depending on the jurisdiction, I went myself to Chicago in 2016, and I was able to present the system to all the prosecutors in Chicago, thanks to Marvin Price and Kalina Tully. And the dialogue that followed was really very lively, very open, frank, in candor, as the Americans say. And that made the difference in the level of trust and how we feel that we can reach to each other and how we avoid misunderstandings. Of course, this is something that has to be entertained during time because stuff changes, and it is something that you cannot do in a one-off situation. So finally, I wanted to say that similar sensations of trust, and trust is one of the themes that Pierre is dealing with in the book for quite some pages. That trust arises also with many other enforcers in the world because we have these meetings that I was mentioning in the ICN. So I want to say that next to the legislation, to the agreements, to everything you can think of, it is very important that the younger authorities also build on these informal relations, because actually the promotion of the fact that we wouldn't have misunderstandings and that we would be aware of what is important for the others and what is really a constraint is what makes us do a better job together. I have seen some questions regarding the dawn rates during COVID times and all that, but I think I don't have time at this moment to address them. I am asking Bill whether I can say a word on that or better not.
Marisa, go ahead, please do.
Okay, because I saw that there were some questions saying that dawn rates face extraordinary obstacles in the COVID era, and how can cartelists be convinced that the virus crisis has not brought effective cartel enforcement to a standstill? How can they be convinced that this is not a cartel holiday? So Dawn raids, first of all, dawn raids are only one of the investigative tools that we have. It is a very powerful one, but it is not the only one. I have conducted several cartel investigations and that have culminated in decisions without conducting dawn raids because either the premises were not in my jurisdiction or for other reasons, for instance, ODD or Forex. Second, the one thing was the moment that the borders were closed and that there was confinement. But even at that, during that time, we have tools that are digital tools, the whistleblower tool and the e-leniency, who have been available 7 hours per week, 7 days per week for 24 hours per day, and they have been delivering. Then the borders are now open, and we have had the time to think through how we would be conducting inspections in this period. So I am not going to share the result of the brainstorming, but the point is that we can conduct inspections and we may resume. Then in locations with sanitary restrictions, then we also have the possibility, if the borders are closed, we have the possibility to resort to Article 22 of Regulation 1, which allows us to request the competition authorities of our member states to conduct the inspections for us, as you know, on behalf of us. And finally, we investigate conduct that has already taken place, and we have 5 years until prescription from the moment the conduct stops, which means that if somebody's in the cartel now, until the cartel stops, the clock doesn't start ticking for prescription and can be investigated. So there is no safe haven there. There is no cartel holidays. Leniency works, ex officio works, and has been reinforced, and we are teleworking. So don't take the risk.
Marisa, if I could just underscore one element of a wonderful presentation, and it's directly linked to one of Pierre's comments about trust. I think you have given us pure gold in your recommendation about the informal mechanisms that can build trust. And if I had to point to one thing that facilitates cooperation, it is the kind of short-term secondment or visitor process that you described, because I think we underestimate how little we really know about other systems. And it's only when you have someone who's worked inside that system with whom you can talk, not just as a professional colleague, but as a friend and trust, that you start to understand what's going on with your counterparts. And from that understanding so often comes a better approach to formulating policy and to working in individual matters. And as you also said, it's not a permanent asset. It wears off over time. It has to be renewed through a series of efforts. But if I had to point to one thing that agencies can do to build that trust that makes it possible to cooperate effectively, I would do secondments on a regular basis. I would do that, and I think you've underscored how crucial that is, and I'm so grateful for your bringing that out. Want to turn to Mohammed. Mohammed and the FSA have again had a pioneering role in several areas. Mentioned earlier, they've been spearheading the development of the cooperation initiative within UNCTAD. They have had an enormously important anti-collusion program. The anti-collusion program has a tremendous government procurement dimension to it as well. FAS has been a leader in recognizing the links between collusion and public procurement. And again, a strikingly important leadership role for the cohort of over 100 agencies created since 1990 that are vital elements of the program today. Mohammed, please.
Hello, everyone. Thank you very much, Bill, for the warm introducing. First of all, let me thank you for the invitation to join this discussion. The issue of fighting cross-border cartels is very important in relevance. I would like to note that Pierre has prepared a highly professional book that will be useful to the entire competition community. And moreover, to note that what I particularly liked in this book is a careful disclosure of each aspect. We faced plenty of problems and specific issues described in this book, and as enforcer, I would like to highlight that the book is very practical and instructive. In the context of this discussion, I can share with you types of cooperation between Russian Competition Authority and other foreign agencies on bilateral and multilateral levels, and some specific issues that we faced during the container liner shipping case. Analyzing our experience, I can highlight 4 types of cooperation between FAS and other foreign competition agencies. The first type is the cooperation within the framework of bilateral agreements. The second type is the cooperation within the framework of multilateral Eurasian treaty between 5 countries. The third type is the headquarters for joint investigations of anti-monopoly law violation in CIS member states, which concentrates on joint investigation in socially sensitive and infrastructural markets. However, despite all our achievements in these agreements on cooperation, we have some limitations. I'll single out the 4 main disadvantages of the previously listed types of cooperation. Firstly, the bilateral agreements are interagency agreements, which are more declaratory and not binding on the state level. Secondly, the existing multilateral treaty covers only the territory of the Eurasian Union. And finally, the headquarters for joint investigations is operational only the territory of these countries, and its decisions have no binding international force. And I would like to stress the last type of cooperation. The FAS enters into so-called new level agreements. The example is the agreement between the government of the Russian Federation and the government of the Republic of Belarus on cooperation. It is the first bilateral international agreement that established advanced tools for practical interaction in law enforcement. Next, as the example of cross-border violation, where we practically faced with many unresolved issues in international cooperation, I can specify the case against container line shipping companies, which was investigated in 2019. It can be specified as a multinational cartel by Pierre's classification in Part 2. For example, the defendants in the case were companies from 10 different jurisdictions. The geographical boundaries of the market, I mean transportation direction, covered the administrative borders of 12 countries, including Russia, Asia, and Europe. So information gathering is really complicated in such a global market. Without going into details of the case, I will point 4 issues requiring decisions and discussions if we really want to fight against cross-border cartels effectively. Number 1 is the trust between competition authorities, as Pierre many times notes in the book. Number 2 is securing the balance of global and national interests. Number 3 is the existence of appropriate legal framework. Moreover, the last but not least is a differentiation of information protection levels. At this point, I absolutely agree with Pierre. As you mentioned in the book, in reality, not all information exchange between competition authorities is confidential. For example, sometimes we need just to get verified information from official agencies about resolved decisions on related cases to analyze the approach, not to get information from the Google search. However, occasionally we cannot do that by different objective and subjective reasons. Now, I would like to finish my contribution and once again to thank Pierre for the great work which revised the cooperation between different competition authorities nowadays. We discussed the book with the head of our department, Mr. Tenishev, and if you don't mind, I would like to suggest the idea of translating the book into Russian, because it can be useful to many colleagues in Russia and in the CIS countries. And finally, to thank the BRICS Competition Law and Policy Center for organizing this really useful discussion. Thank you very much for your attention.
Thank you so much, Mohammed. One thing I've noticed that's so valuable about the philosophy and approach of FAS is that you have been so informative and generous in taking your experience in your role as a major participant in a regional network, the participant in a global network, BRICS, and in your bilateral projects in distilling experience about how those forms of cooperation have worked, because I think an indispensable element of making progress here is to have very informative discussions about the experience you are actually having, what's worked and what hasn't. That's really the raw material for building better frameworks going ahead. And in so many forums and so many discussions, you and your colleagues have been doing what you did today, which is to make that available. And without that contribution, you can't make the progress that we've been speaking of here. Our third representative from a national authority is Hardeen. Again, you have today in the webinar, you've got representatives of the really the best we have to offer in the competition policy field, and the Competition Commission of South Africa has been so instrumental, not simply in building a vital hub in Southern Africa, but as Hardeen knows, you're really a prototype for what a newer authority can do globally. So the experience that you have has not just been important for South Africans, for Southern Africa, but you're really a bellwether authority for the larger world. So we're thrilled to have you here today. Hardeen, please.
Thank you very much, Bill. And thank you for the very kind words. You remind me because you once shared with me that until we are 25 years, we have not seen much. So we only turned 20. We will be 21 this year. So we really take the compliment, but also note that there is a lot of work that lies ahead for us. Indeed, today's book, launch of this book, it's a significant step, I think, a step forward for competition authorities globally. And as my fellow panelists have been saying repeatedly, trust is the lubricant, and I quote from Marcus Bass's interview. And I call this the thrust, because it seems to me until we get to know each other, until we get to interact as authorities, we would most likely still face challenges. We may still not even understand our different regimes, our different practices. The book has received quite raving reviews. Pierre, and I congratulate him because he called me to give my initial sort of impressions of the manuscript, which he kindly included as one of the reviewers of the book, and this appear very well done. My talk, I wanted to focus on challenges because it seems to me trust, indeed, it has been stated. There's a difference in leniency programs, and this is what is reflected in the book, and differences in cultural legal barriers. And what is it that we can do as authorities? And fortunately, there is a lot of work that has happened in this space. In fact, Pierre's book just dovetails with the work of the OECD, the work of the ICN. In fact, there's an ICN. We have increased focus in the area of international cooperation for cartels, BRICS. This is what we've been doing, UNCTAD and OECD. But what has been crucial for South Africa, if I can share this with you, is that we have a few success factors that I wish to share today. The bilateral and multilateral cooperation arrangements through formal MOUs have been quite useful for us. We are a young authority. We have learned a lot from this. Participation in global fora, enabling legislation. We don't take this for granted because the manner in which our legislation has been crafted does allow us to do what we do. A supportive government and legislature. the government of South Africa is fully behind competition policy and regulation. So this is a priority of our government. We do have quite established institutions, and the judicial review process in South Africa is quite transparent, which helps in us tackling these issues. As you know, and the issues that we've picked up, there's an question of jurisdiction for younger authorities on these cross-border cartels. What do we do with a cartel that has an effect in the domestic jurisdiction but don't have residency in our country? So we have had quite good cases in South Africa that have clarified this for us. And the key cases that we have looked at, the forex cartels, cement cartels, components, and shipping lines. These cases have been reflected well also in the book. And we see a very promising post-COVID future where cross-border cartels will remain an area of focus for competing authorities globally. There are currently deepening measures to deepen cooperation in tackling a cross-border cartel. The UN set of principles and rules on competition, OECD recommendations, regional bodies, and we do look forward to the 8th UN review conference, where we will be looking into an annex to bolster international cooperation to combat cartels. And in conclusion, Pierre Horner has done well here in demystifying myths about perceived limitations of small and young authorities in tackling cross-border cartels. So this is quite a useful addition to the world, as you say, not just to the young authorities, but to the global community as well. Thank you.
Thank you, Hardeen. And you're too modest, I think, to bring this out, but I think one of the secrets that we've observed in the last 30 years is that it is the younger authorities that are a source of great vitality and innovation. In some ways, they are the equivalent of new entrants who do not necessarily have fixed conceptions about how things must be done and what cannot be done. And I think what is so impressive about your experience, even though it is a relatively new experience, is that you've become a prototype and a testing ground for approaches that older institutions can take on and think about. And in a way that I think older institutions are only now understanding, your experience has been a stimulus for self-reflection and change, because you've provided a benchmark from the outside about how we think about the field. So I see tremendous bilateral gains in trade here between the experience of the older institutions and the newer ones. And I don't think there is an older institution that has worked with you and your colleagues that has not understood that. And I realize there are many rivers to cross for all of us, but that has been a major influence of newer competition authorities in the field of cross-border cooperation and enforcement generally. Thanks for highlighting that for us. Going to turn to reflections from those outside of the competition policy enforcement community. And we have again, 3 wonderful perspectives that bring together practice, bring together an academic orientation to enrich our discussion. And once again, the UNCTAD Secretariat, the BRICS policy team have picked exceedingly well. Want to turn first to Claudio. Notice not only Claudio's own career experience, but he's part of the Latin American hub for ESCOLA, which is an association of academics external to the agencies, but I would say friendly external observers. Claudio, your own thoughts, please.
Thank you very much, Bill. Thank you. I'm here indeed talking to you from Eurasia, and I would love to thank everyone. Thanks, Alexei. Thanks, the BRICS Center, and thanks for inviting me to comment on this important book. Aware of time constraint, I will cut it short, and I will try to be very short. So, as I said, this is a very important book because everyone seems to be in a time where when everyone seems to be concerned with the technicalities of competition in digital platforms, as you mentioned before, and I've been guilty of that too. It refocuses the attention on issues that affect the lives of billions of people. As we know, cartels, but I would say also many other forms of anti-competitive agreements have been labeled as the absolute evil, not without good reasons. The book is important because it takes the perspective of developing countries, soliciting for collaboration rather than outright imitation. I really believe that rather than pushing for legal transplants, it is fundamental to appreciate differences between enforcement mechanisms. And this book does that, definitely. They should, certainly these enforcement mechanisms share some common principles, as it was said before me, such as procedural fairness. But then to follow what Professor Chang has recently labeled as principle of informed divergence. So they should probably follow rather this principle. Since this book concentrates on cooperation, the book is also very timely because in a time of decline of multilateralism, cooperation is ever more important. Indeed, with the decline of the multilateral model, self-regulation and the lex mercatoria are naturally acquiring more importance, thus further blurring the line between pro-competitive cooperation and anti-competitive agreements. This book is also a great, for me, a great source of information for scholars, practitioners, and enforcers, as it manages to bring to unity many of the issues related to cross-border cartels. And thanks to these, it may become part, actually I hope, and I think it will become part of a theoretical framework within which further research can take place. In particular, here I had a number of ideas. Many of them have been already touched upon. So given the time restraint, I will not repeat things that have already been said. But let me just focus on a couple of things that have already been said, just to add something to the discussion, and then go on three topics that instead haven't been touched upon so far. So first of all, leniency applications and creation of trust. Pierre very rightly focuses on the creation of trust between enforcement agencies. Here, though, we have to say that some research also on creation of trust between agencies and the business sector is fundamental, especially for developing jurisdictions where antitrust authorities very often lack that trust from the citizens and the businesses that are operating within their jurisdiction. Here there are a number of studies, including a study of the OECD in 2013 that documents this lack of trust. So using his research to retooling his research to focus also on this type of trust would definitely solve many of the problem of the lack of enforcement of antitrust in this sphere. On COVID-19, we have seen that some developed jurisdictions have already started enforcing their antitrust laws against national and international cartels, such as in the UK and Italy. But to do so, they had to reallocate resources. So, for example, the CMA had to stop some of these, as to put on hold some of its investigations. Now, here, developing jurisdictions simply don't have the capacity to do so. So, to develop further that trust, probably develop a jurisdiction may provide then intelligence to newer institutions, especially in this time of crisis. Again, from a perspective of from an institutional perspective, often in developing jurisdiction, political captures jeopardizes the outcomes of international collaboration. Here, institutional design would be key. because this might lead to the creation of authorities that possess certain characteristics such as timeliness of decision making, predictability, expertise, transparency, independence, efficiency and effectiveness, and accountability. And it would make this collaboration possible and effective. Here, local researchers and enforcers could cooperate to help ensuring this change. And I mean, local researchers from different disciplines, including administrative and public law and governance. Now, there is something that hasn't been mentioned yet, digital markets, and I have to touch upon it. Digital markets are bringing new problems to the table. Global value chains are going digital, and we need to reconsider our approaches to detection and prosecution of cartels on or facilitated by digital markets. Here, algorithms and among them specific technologies such as blockchains that are already used in international trades pose new hurdles to antitrust enforcement. Now, there are a number of other issues that could be developed on the basis of Pierre's book, such as, for example, the development of private antitrust enforcement as a deterrent, to transnational cartels, but also the risk of developing private antitrust enforcement in developing jurisdictions, in particular by the recognition and enforcement of foreign decisions. But in general here in this, since I have very little time now remaining, in this, from this point of view, I think that one thing that should be explored maybe by some other researchers is that the development of regulatory regimes may bring to forum shopping in the future. And we have seen to some extent also this happening between the United States and Europe. And I believe this will take place on a global level in the future. And this, especially with regard to cross-border cartels. Now, I think that finally, my final comment is that probably from the perspective of scholars and not enforcers, but from an academic perspective, we need probably bold statements. And this bold statement may, for example, consider the detrimental effects of cartels in that take place that are implemented in developed jurisdictions to the livelihood of people in developing countries, but also the detrimental effects on the environment as a violation, for example, of fundamental rights that are internationally recognized. This obviously is easier to say than to do, but if we don't start the conversation, especially at level of the academia, this will never be really developed. And we will never know if this can be also implemented at enforcement level. So again, I would like to thank Pierre for this book that we all study and use in our competition law courses, obviously. And I would like to thank again for giving me this opportunity to give a very brief comment on this book. Thank you very much.
Thank you, Claudio. One thing you mentioned that I think is important for all of us going ahead is to recognize the value of the collaboration among academic researchers, the international networks, and the competition agencies. That is a fruitful partnership, can perhaps be used even more extensively to engage academic researchers to do the kind of work, extensions of the kind of work Pierre has done, to bring the resources of academia to bear in addressing these questions. And your agenda of topics is a very good one, but I don't think agencies can do it by themselves. I think unless they find this partnership and collaboration with external organizations, academic hubs, I don't know how we get there, but you point the way to resolving that by bringing this larger pool of resources to bear. Juan, I'm going to come to you, another perspective, both from practice and from academia. Again, part of the Escola Network in Latin America. Juan, please.
Thank you, Bill, and thank you everyone for organizing this event, especially the BRICS Competition Law Center. Congratulations, Pierre, for your book. I remember clearly when we met at Oxford and you were on your sabbatical, and I remember your hopes, your dreams with the book, and I'm so happy to see that the dream came true in this case. So congratulations, Pierre. I'll start by sharing just one slide, if I may, to show how does competition law in Latin America and the Caribbean looks like. This is a map with 23 different countries that have national competition laws. And you see the icons of 29 national competition authorities and 2 supranational authorities. So, well, the first thing that you would notice is that there's great heterogeneity among these countries, and obviously among their competition agencies. One of the things that I like about Pierre's book is that, as Hardin mentioned before, is that it tears down several myths. One of the myths that he tears down, and it's in the end, in his conclusions, he says, anti-cartel laws in emerging markets are still in their infancies. Well, that's a myth, clearly. In Chile, just for example, the competition law has been enforced for almost half a century. So you could say anything but that they're in their infancies. Certainly, other close countries such as Paraguay or Uruguay have few years of experience enforcing the law. But among these 23 national jurisdictions and 29 national authorities, there's all sorts of experiences, different trajectories, and what's interesting is that among the competition law systems in Latin America in the last decade or so, we have witnessed, let's say, a pollination among competition authorities. Just to give you an example, the first decision that was taken by the competition authority of the Dominican Republic, in which they sanctioned a company for breaching competition law, they cited 6 different cases from Latin American peers. So nowadays, competition authorities from Latin America and the Caribbean don't have to look north or don't have to look anywhere else to understand how certain markets work, what certain remedies may be considered, theories of harm, because their peers are already working on that and have something to teach them. And that's something that the ICN events, OECD events, or in Latin America, the Inter-American Bank events that gather Latin American competition authorities, well, they of course contribute to this dialogue among competition authorities, which gives us a better chance to learn. Because the next, and I'm not sharing the slide anymore, the next myth that Pierre tears down in his book is that the small jurisdictions and the young jurisdictions are only there to learn. Well, actually, small and young jurisdictions can also teach other jurisdictions, both peers and the so-called mature jurisdictions. Just a parenthesis, would you now want to learn how the US or the UK are dealing with COVID-19? Maybe you should watch other jurisdictions, smaller jurisdictions, younger jurisdictions in the world that have dealt more successfully with COVID-19. Well, something very similar happens with different areas of antitrust law. And in that sense, I've been in touch with colleagues from Ascola, from other jurisdictions, to work on a project in which we can identify how countries from emerging countries can shed light to, let's say, developed countries. We have an issue actually with the taxonomy. We're not sure whether we should tag it developing, emerging, mature, or global south versus global north. We're still handling that, but we do think that there's lessons that these younger authorities can teach others, not just their peers, the younger ones as well, but also the mature ones. And one of the things that we came up with is that there's still a barrier for learning, and it's language. I recall there was a colleague from Hungary that asked me, well, but why do you think that in Latin America, aside from the Latin American cases, people tend to read EU case law rather than case law from Croatia or Serbia, or economies that may be similar to the ones that appear in most countries in Latin America? And my first answer was, well, we don't have access to decisions from the Croatian authority in English. Or most of them are not in English, at least. And I would say the same from Thailand or Vietnam or other countries that would be interesting. And this is why I'm mentioning this language barrier, because I think that one of the most important contributions that Pierre brings in his book is actually telling us about many cases, of course, mostly from Latin America, but from other jurisdictions as well, about cross-border cartel enforcement. And for many people in Africa and Asia, maybe they wouldn't be able to access that knowledge about the Latin American cases if it wasn't for this bridge that Pierre is offering with his book. And I'm not sure whether the English will be our language bridge. Maybe it can be the case. But certainly we need a more inclusive conversation with regards to competition law and policy. Of course, you can say that about other policies and laws, but we're speaking here about competition law. We need a more inclusive conversation. And for that inclusive dialogue and that exchange of ideas, well, we need more scholarship that offers lessons from Africa, from Asia, from Latin America, not only about cross-border cartels, but many other issues that are important. And as Bill was saying, well, the new entrants in competition law enforcement and advocacy are making very interesting contributions that are probably not being heard of. Examples from Central America about how to promote the culture of competition, about educating the broader public, the efforts from the Dominican Republic to engage with the public through social media. In addition to cross-border cartels, there's other areas in which the so-called younger or smaller jurisdictions have many things to offer. And with that, I'll close my remark. And again, I think you should, of course, buy the book and learn about Pierre's research. Thank you.
Thank you, Juan. By the way, if you're wondering whether it makes an excellent gift for anniversaries, birthdays, or other occasions, I can only assure you that it does. But that's again, a wonderful reminder about the rich source of insights that exist in the younger jurisdictions. Sometimes we refer to the older ones as mature. I'm not sure how mature they are. They are older, but maturity is a bit of a loaded English word that suggests elevated consciousness. They are older, to be sure. But I think you're so right that if we don't focus on what's taking place in these other regions, we're missing a good game because they are a tremendous source of vitality. In Latin America, you can argue that the Lava Jato, which has cross-border dimensions, the matter being pursued in Brazil, there's the most important competition case in the world today for what it means for political science, for public procurement, for the entire region. In short, these are the laboratories in which really good science in our field and applications is being done. Dave Anderson. Dave is a practitioner, but not simply as a practitioner. Dave is a real friend to the competition policy system, generously devoting so much of his time to UNCTAD events, to the observation of the international networks, and a crucial way to see that theory meets practice in a useful way. Dave, your thoughts, please.
Hey, Bill. Hello, everybody from Brussels. Maurice, I'm just down the road from you. Pierre, congratulations on your book. I did buy a copy. It will go under the tree for somebody. I will, share with my friends. I expect it to be autographed. Bill, thanks a lot, and thanks to everybody for this great session. I've learned a lot from everybody today, and I hope I can put in a few notes of my own right now on this really important subject. I'm really glad that we're talking about it today. I am coming at it from the private sector view. I sit in the chair here of my law firm here in Brussels, and I work around the world with a lot of you in your various jurisdictions. And as Bill said, I'm really happy to devote time to UNCTAD and ICN, bilateral work, for the sole purpose, really, of not any axes to grind, but really trying to help us to make better systems, sound systems, fair systems, and procedures, because I never know where I'm going to be. I could be on one side or another. I could be doing one thing. And so I'm always trying to heed my grandfather's dictate, where he says, where you stand depends on where you sit. I never know where I'm going to be standing. So I'm really happy to always help try to make sure that we work on this. And from my perspective as well, to really look at raising awareness. And this also affects a lot of my clients who are acting in developing economies, getting compliance down and trying to help with fairness and convergence, because I think they're really important topics here, particularly in the area of cooperation. So that's why I think Pierre's book is so important, because Pierre, you talked about so many of these issues in such a coherent way that is helpful. It's written down in a book that I can hold and make notes on, which is really helpful. So, today you talked about, cross-border cartels, you talked about the crisis, you talked about cooperation, and I really just want to throw out a theme to all my friends who are in this field of working with regard to mature jurisdictions, experienced older ones, younger ones, developing economies, changing economies, really on the subject of it's good to talk. It's good to talk. And it's good to talk, one, to your friends. Depend on your friends and agencies, right? This cooperation, which is such a big theme in Pierre's research, that this is really still a really young issue in our field. The advancement of cooperation, has accelerated, but it's still very young. And so I really have always said this at all my UNCTAD participations, for agencies to really not feel that the boat has gone or that you don't have any say in this. This is still really a young, emerging, changing part of our practice. And so I really would encourage agencies to become involved because it is still coming on the uptake for a lot of folks. And I would like to, to see more of that, not just the transatlantic or big agency to big agency. I think that it can really help. Second is convergence. I really think that convergence can drive cooperation. I think several speakers have said today, when we speak the same language, we have the same terms, we are talking about similar procedures, we can cooperate better. And to me, that's fundamental. And if we can't, there is that concept of informed divergence. At least we know why we disagree, so we can move on and perhaps continue to cooperate well on that. I want to touch on COVID real quick, because there are global examples from so many agencies, the European Commission, South Africa there, the FAS who are there. You all have done great work in putting out guidance or issuing decisions or comfort letters or exemptions, which really make it clear to the business community where you stand and what they should be doing and not be doing. I think that's super important work, and agencies who are thinking about that have a wealth of public material that's on the websites of all the agencies that you can stand on the shoulders of. And also, with regard to advocacy, that's another big point that I really believe that everyone here is super devoted to. Awareness raising. This is really important. In the private sector and in business community, awareness is actually quite low. We may think it's high because we spend all our time doing this area, My experience is it's low. We've done many surveys in different fora to show that it's low. We have to keep telling them and telling them again and using the resources. If you're doing it, great. If you feel you don't have the resources for it, again, depend on your friends. All these agencies here today and all around the world have put together great materials on their websites that you can use. Prevention versus cure, much cheaper for your economies. And secondly, talk to the private sector and to the business community. I heard Claudio mention this. I think it's a really, really important point to help drive one of Pierre's themes in trust and confidence and to promote best practice. In the private sector, very often we are your proxy. We're the first touch of competition law with businesses, with the boards, with the salespeople. We are the ones who are conveying the messages of compliance and what the law says. And a really good example too on how private sector can help. Marissa, you may remember back at the beginning, the leniency program in Brussels didn't work very well. It didn't have things that we could show to our clients that made it give them the incentive to go forth and go for leniency. We changed it in 2002, and the private sector there, we worked together a lot on explaining it to business to say, actually, if you are in trouble, this program does work now. You can have confidence in it, you can trust it, and you can move forward. So there was a lot of that work together. Same on waivers, information sharing. Pierre, you talked about a lot in your book. There's a lot of confidence and trust issues there as well. And I think that's really important too, to promote to the private sector that you have a good track record of maintaining confidentiality, have good processes, and your information will be handled safely. That helps to promote trust. And then lastly, on the advocacy point, I really think that's where we have the shared interest, right? We have a shared agenda that compliance is important and raising awareness. And with regard to trying to do this in some countries where leniency may be difficult, in smaller economies, getting companies to go for leniency may be difficult. So that's where you have to rely on compliance and awareness to try to drive a healthy economy. And lastly, just on the COVID point too, talking to business about what you expect. Many of the agencies here, especially Hardeen's agency, I've seen has done a lot of advocacy work directly. And the commission here in Brussels as well, fantastic. Came right out of the gate with good information right away. Here's where we stand, very clear information. And that I could explain to my clients. If you need to go into a collaboration, which may be a little bit unusual, here are some of the current up-to-date right now guidelines. Again, if you don't have a lot of resources for this, so many countries around the world have done this. I'm publishing an article, sorry, Pierre, tomorrow in concurrence. We're doing a special COVID one. It has maps of every country doing this kind of work. Please feel free to go on that and have a look, because there's so much work going on. So for me, talk to your friends and talk to the private bar and the business community. I think that will help drive a lot of the work that Pierre's really trying to get through in his book. So thanks a lot, Bill. I'll stop it there.
No, Dave, thanks. I mean, it's such an important reminder that the private sector and their advisors are crucial transmission devices in our whole system. They convey the messages out to the business decision makers. They help them design compliance programs. They teach them what to do. But they're also a useful source of feedback to the authorities about what's working and what's not. And authorities don't have to credulously believe everything they hear from private sector figures. But I think you're crazy not to listen. If an advisor says, that's a nice airplane you have, but I noticed that it only has one wing on one side and you might want two, that's information that's useful to have. That's why your plane isn't flying very well. That's good to know. And likewise, I mean, your observation about the importance of having a better mechanism to assemble the knowledge that we have and make it available and accessible to individual authorities. That's the work of the international networks. It's the work of the non-government institutions in academia, civil society, professional societies. There's a lot of useful information, but in a downpour, in an avalanche of information around the world, and you're a public agency, how do you take it in? How do you even know that it's there as a way of going about making decisions? Alexei, I know we're at or beyond the outer boundary of our time. Should at this point, I ask your guidance, should we wrap things up at this point?
I think it's extremely important to ask our author maybe to say a couple of things, what he heard about it. But what I want to announce that actually this session, these beautiful sessions, it would be published as a video file, and you can watch it later on. But most importantly, we add to this video file another video file, which would be merged with this one, where Pierre, the author of the book, would reply a number of questions we collected before and during the session. So it would be comprehensive kind of response to all the inquiries.
That's great.
Maybe I would suggest, if you don't mind, Bill, just to give Pierre a couple of minutes to say. And I think we had a great session, and I think it would be just the beginning of great journey, fighting cross-border cartels. And let me encourage once again to everyone to tune up to the session, which would be at the UNCTAD event in October. Hopefully attended personally, but maybe virtually it would be also available. And that would be where we're going to present some findings of this empirical study we're doing using methodology, which is coming from the book of our great author, of our Pierre Orner.
Thanks, Alexei. That's a great approach. Pierre, some closing thoughts. Then we will we'll thank everyone and sign off. Mr. Author, your final observations for today.
Thank you very much, Bill, and thank you very much, each of you. I really enjoyed the session and the thoughts that have been provided today. I think that the areas that we have discussed are extremely important still in these times of crisis. We have seen a number of areas that we need to be very much cautious. And I'm so happy that we are always tuning on the same page with regards to the importance of international cooperation in times of crisis, precisely. I am happy also to see that the thoughts that I put together in this book can be translated in other languages, and I am happy to see that our colleagues from the Russian Competition Authority will be interested in having this translation in Russian available as well. I also would like to particularly thank the speakers that talked about the issue of trust. I think that it is important to see that trust has different type of levels, and it is a building process. And that's precisely why I devoted a lot of time in this book to see how we build trust between institutions. And it's just not a matter of what we always say, that it is magic. It comes with time, but they are a specific type of experiences that we have seen so far lately, also in different regions, And the fact that I have showcased Latin America, maybe I did not say that in my initial presentation, it's because my first 10 years in UNCTAD was precisely devoted to work for Latin American countries. And I was witnessing a lot of great developments during the 10-year experience that I had assisting and accompanying competition authorities or very nascent competition authorities that catch up very quickly. But it's not only about Latin America. In the years after, we've seen a tremendous catch up for other competition authorities around the world. In the Asian region, ASEAN region, I would like to commend the work of the Philippine Competition Commission. And precisely because of that, I asked the chairman of the Competition Commission of the Philippines to provide some words at the beginning of that book, of my book. And I think that it is interesting to see how we are actually working on this particular field. I would like just to refresh the 4 questions that I ended up my presentation. That's just sharing the 4 questions again in line and in actually crystallize on what it has been said so far. So on the first question, it is important when we talked about research capabilities and potential, I think that the digital economy, and I think Gloria also said about that in perspective, it is a matter of understanding what would be the great challenges that we will have when it comes to the digital economy. And for that, we are in UNCTAD preparing a specific session on the interlink between competition and consumer protection issues in the digital economy. But there's also the area on the second question I posed, which is in connection to what other speakers talked today about the danger of triggering additional global or at least transnational anti-competitive practice post-crisis. We are more or less forgetting that because of the importance of economic recovery of SMEs. And I think that when it comes to that, we need to always strike a balance between what is important for the economy and what would be harmful to the economy in any type of instance, whether it is in crisis or non-crisis activities. On the third point that I put forward at the last part of my presentation, we were talking about the options available for developing countries' competition agencies to counteract this potential anti-competitive effect. And I think it is connected to the fact that whatever is happening now and in the future, we need to be vigilant. Competition authorities around the world, not only in the developed or developing world, need to be vigilant on what is happening currently, particularly on these two areas, the digital economy and the pharma sector. And I think this is an important part that, that the book could provide some avenues for discussion in terms of neutralizing the harmful effects of these very, very harmful practices that affects the development of many, many competition authorities and many countries around the world. Thank you very much, Bill, for moderating this session, and thank you all for being here today, and to the more than 500 registered participants that are with us from all over the world. Thank you very much.
Thank you, Pierre. Thank you for colleagues for underscoring the important connection across agencies with academic hubs, with international networks, with non-government organizations of all types, how the collective solution can be a lot better than simply individual effort. And again, thanks Alexei and Anna, the entire team at BRICS for making this happen. And Alexei, perhaps a closing word from you.
Thanks, Bill. And my closing words is congratulations, actually, to our author and to you. I think it was a beautiful moderation we had, and very time, we basically complied with all the timeline. It's amazing. It never happened in my life, in the big competition law and policy debates. And so that's actually already success of cooperation. So we have shown that people from all over the world, from different authorities, from private sector, from academia, we could cooperate at least on one thing, how to comply with the agreed timelines and agreed topics. And we basically had this discussion, I think, extremely fruitful, and it's showing that we can build trust among, institutions, among people, and then to fight this disease. As you said, this disease is mutating, is changing, is going to avoid, as much as possible compliance. But Pierre in his book was mentioning that we're trying to catch the uncatchable, but I think it's pretty uncatchable. It's like virus. We just need to understand it better, and we get it, and we will get it together. That's my final word. If anyone wants to say something, I think, Bill, it's up to you if you want to give a word, but
just thanks, panelists. A brilliant job all around. As I look at the screen and I look at the presentations, I do see the face of a better future, and it's extremely encouraging. I think the talent is there. I think the will is there. I think we have lots of good suggestions. Let's all get back to work and do it. So thanks to the whole group. Thanks to our hosts.
Thank you very much. Goodbye.
Thank you.
Goodbye.
Bye.
Thank you. Bye.
Thank you.
Farewell.
Bye. Bye-bye.
Thanks, Bill.